Can Mr. Angwin expect to have the same privileges of excusal, video conferencing as Mr. Kenyatta has had?
You recall in 2013, at the Assembly of States Parties, there has been this challenge and this push for the rules to be amended of compulsory appearance before the ICC judges. And this amendment was suggested by Kenya because they claim or they said that Mr. Kenyatta and Mr. Ruto have extraordinary responsibilities as leaders of a state to be able to be appearing continuously before the judges of the ICC. And this amendment was passed by the Assembly of States Parties. I do not think that Mr. Angwin can claim those same responsibilities to be able to request for excusal. In fact, I'm not sure, but I do not think that that kind of rule, that amendment of the rule, would apply to Mr. Angwin, given the fact that he is neither a head of state, nor is he a leader with extraordinary responsibilities, as has been interpreted in the rules.
So we can now confirm that actually being a president or deputy president actually gives you special privileges before the ICC.
I still don't, have not agreed. In fact, I have argued against that before the judges of the ICC. But certainly the fact that they are presently leaders of a country has had an impact on their ability or their responsibility to be able to continuously appear before.
Mr. Angwin also has got a long history of being abducted as a teenager or young child himself, and all this history about being forced to commit atrocities. Will that affect the way you prosecute the case?
It will not affect it. If you look at the charges that have been brought against Mr. Angwin since 2005, the charges were always against him when he was actually an adult, above the age of 18. As you know, no person below the age of 18 can be prosecuted before the ICC. So the charges that we have brought against Mr. Angwin has been when he was an adult and allegedly committing all these crimes. So we will be arguing that point before the judges.
And so you will not be taking into account the fact that he was forced into a life like this, as he says?
As I said, we know about that. We know about the previous life of Mr. Angwin. We have heard about the abduction, that it was done before when he was below the age of 15. But we have gone ahead and charged Mr. Angwin for crimes that were committed when he was above the age of 18. And those crimes, they're very serious crimes. We cannot take it lightly. And it will be up to the judges to decide. Maybe this can be a mitigating factor, probably. But what I can tell you now is that the charges that we brought against Mr. Angwin is when Mr. Angwin was an adult and allegedly committing these crimes.
Finally, the Palestinian issue, which you have seen a lot of politics come into it. You know, Palestine became a state party to the Rome Statute. How does the ICC see itself navigating the political waters like this?
I will straight away say, but just doing our legal duties. That's what I would say. But really coming into the Palestinian dossier, if I may call it that way, the office has been very consistent in the way we have handled this situation. And we have always handled it very carefully, looking at all the legal issues, looking at all the, the criteria, the parameters, and strictly working within the statute, the Rome Statute, and the policies that we have in this office. You will remember that in 2009, there was a declaration by Palestine accepting the jurisdiction of the court, declaration under Article 12.3 of the Rome Statute, which can be made by a state non-party to the Rome Statute, accept jurisdiction for ICC to intervene, just like Ukraine has done, and just like previously Cote d'Ivoire had done at a time when it was not a state party. At the time, we had said that after, I think, 3 years consultation, we had, from all parties, all sides, even academia, we decided that because the status of Palestine then at the UN was a status that could not ratify treaties, we therefore said that this declaration is not a valid declaration because of the legal, it did not, the legal validity of the declaration was lacking. As a result, at the time, my predecessor decided not to open investigations into the situation because of that reason. And in fact, we indicated at the time that if Palestine were to, the status of Palestine were to change at the UN, and they're able to ratify treaties, or that they're able to make a valid declaration, we will reconsider that decision. In 2012, the United Nations General Assembly decided to accord Palestine a non-member state observer status. A non-member state observer status, which means that Palestine, for us in our assessment, that Palestine could now ratify treaties, in this particular case, could now ratify the Rome Statute and be also consequently make a declaration under Article 12.3 accepting ICC jurisdiction. So this happened, and in January of this year, Palestine decided to first lodge, decided to ratify the Rome Statute and deposited its instruments of ratification to the UN Secretary General, which was accepted by the UN Secretary General as depository of treaties, and also at the same time decided to make a declaration accepting the jurisdiction of the ICC. At the moment, my office has assessed that now this declaration under Article 12.3 is a valid declaration. And in accordance with the statute and my policy, I have decided in January to open preliminary examinations into the situation in Palestine. For the office, I want to be clear, it has never been about statehood of Palestine, determining statehood. It has always been about the status of Palestine at the United Nations, always. And we have been very consistent in this, with this always. What does the preliminary examination entail at the moment? There has been a lot of reaction since I opened a preliminary examination saying that Israel is being hauled to the ICC, that certain individuals will be charged, etc. I just wanted to be clear that preliminary examination is not an investigation, and nobody has been charged before the ICC at the moment. Preliminary examination is about looking into certain aspects, whether, for instance, the jurisdiction of ICC has been established in terms of, for instance, the crimes that have taken place, the alleged crimes. Also in terms of complementarity, meaning is there any national proceedings ongoing, in terms of gravity of those crimes, and also whether it will not be against the interest of justice for the ICC to intervene in this situation. So these are really the four aspects mainly that we are looking at currently. And we can receive information from all reliable sources during this process. Also, there is no timeline for this preliminary examination. Everything depends on the facts and the circumstances. So this is something that maybe people need to know, that this is what is happening currently. It is only at the end of this process that a determination, I will make a determination whether to open investigations or whether not to open investigations or whether to continue to collect additional information to continue with the analysis. Can you give us a sense of where the status of the issue around the UK and Iraq is at in the United Kingdom? Because that's one that's been quite interesting, because I think this is the first one that perhaps involves one of the older democracies, and
and where that's at?
Last year, I also decided to reopen preliminary examinations into the situation of into the alleged crimes, torture, abuse, allegations against the UK Defence Forces in Iraq. And I also want to just explain, to be clear, that I am not making a preliminary examination into the whole situation in Iraq, because Iraq is not a state party. But ICC has jurisdiction over the territory of a state party, but also nationals of a state party. Now, we are investigating, we are collecting information for preliminary analysis against nationals of a state party allegations, and that is the UK Defence Forces in Iraq. This is what is happening. Again, as I said, timeline, there is no timeline. What is currently happening is that we've started collecting our information. We are also receiving information and cooperation from the UK authorities, who are also looking into the issue. They tell us. So we are going to collect all this information, not only from them, but also from other sources, reliable sources, and we'll make an assessment of this situation and make a determination at the end of it, whether we have to open investigations or not. Because if you compare what happened, why we closed the preliminary examinations we previously opened over this same situation, the information that we have received now is much different. It's very different than the one we received previously. In terms of numbers, I remember we were dealing with 14, maybe under 20. But now we're talking about allegations of maybe 400, etc. And this is really quite, for us, quite alarming, and necessitates that we look into it again more closely. This is my reason for opening this preliminary examinations against the concerning the UK forces and their conduct of alleged abuse in Iraq.